Section 18 of Tribal Custom and Anglo-Saxon Law. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Tribal Custom and Anglo-Saxon Law by Frederic Seebohm. Chapter 7, Tribal Customs of the Tribes Conquered by Charlemagne, Part 4. 4. Lex Angliorum et Verinorum hoc est Theodorum. We may probably follow Richthofen in his conclusion that the Thuringians of these laws were the tribes settled with the Anglii and Verini in North Thuringia, and that they were promulgated under Charlemagne about AD 802. In the first title, the Vergels for homicide are stated: Adeling, 600 solidi; Liber, 200 solidi; Service, 30 solidi. These are evidently unaltered gold values. The rest of the first 5 titles relate to wounds, and we need only mention that the destruction of an eye, hand, or foot, or a blow causing loss of hearing, was to be paid for with half the vergeld of each class, following in this respect the custom of the Frisian and Saxon tribes. These 5 titles in the Convict manuscript of the 10th century constitute a whole under the title Lex Theodorum. The remaining titles are, in this manuscript, added to the Lex Saxonum, to which, however, they do not appear to belong. The triple vergeld of the adeling of these laws may have been the result either of noble birth or official position, or both combined. The vergeld of the Liber of 200 gold solidi, presumably of 3 trimisses, seems to connect the customs of the Thuringian tribes of these laws with those of the Salic and Ripuarian Franks, rather than with those of the Saxons and Frisians. It is worth notice, too, that, while in the Lex Saxonum and the Lex Frisonum, the figures seem to follow a duodecimal system. In these laws, the more usual decimal reckoning is retained as in the Lex Salica. The fact that among the additional titles there is one de allodibus connects still further these laws, notwithstanding their later date, with the Salic and Ripuarian laws, which contain similar titles, and it is worthwhile for purposes of comparison to give it at length. 1. Hereditatum defuncta filius non filia socipat, si filium non habuit, qui defunctus est, et filium pecuna et municipa, terra vero et proxima paterni generationis consanguinan pertinent. 1. Let the son of the deceased and not the daughter receive the inheritance. If he who has died had no son, to the daughter shall go the cattle and slaves, but the land shall pertain to the next blood relation of the paternal generation. 2. Si autem nec filium non habuit, sora aegis pecuniam et manciapia, terra proximus paterni generationem accipitet. 2. But if he had no daughter either, his sister shall take the cattle and slaves. The next of the paternal generation shall take the land. 3. Si autem nec filium neca sororum habuit, sed matrum tantum superten reliquit, quod filia vel sora deverit, mater suspiciet, it est pecunum et mancipia. 3. But if he had neither son nor daughter nor sister, but he left a mother only surviving, what daughter or sister should have had, let the mother take, i.e., the cattle and slaves. 4. Quasi si filium et filiam nexorium aut matrum demissit superstitis, proximus qui fieret, paterni generationis, haris et toto succedat, tam in pecunia acti, in municipis quam in terra. 4. But if he leaves neither son nor daughter, nor sister nor mother surviving, he who shall be next of the paternal generation shall succeed as heir of the whole, as well in cattle and slaves as in land. 5. Et cumquo Herodotus terri pervenerit ad illum vestis bellica, it est lorica, et ultia proximi, et solutio ludus debet perterni. 5. And to whomsoever the inheritance in the land shall come, to him ought to pertain the coat of mail, i.e. the byrnie, and the avenging of the next of kin and the payment of vergeld. 6. Mata moriens filio terram, mancipia, pecunam dimitat, filia vero spoilio coli, it est numeralis, muscus, monala, inoris, vestis, armilis, vel quicquid ornamenti, propria videbatur habuis. 6. A mother dying shall leave her land, slaves and goods to her son, but to her daughter her neck treasures, i.e., necklaces, buckles, collars, earrings, robes, bracelets, or whatever personal ornaments she appeared to have. 7. Sic nec filium habuit, servorum vero habuit, servori pecunam et mancipia, proximo vero paterni generis terram relinquit. 7. If she have neither son nor daughter, but have a sister, to the sister shall she leave the cattle and slaves, but the land to the next of the paternal kin. 8. Usque et quintum generationum paterna generatio succedat, pot quintum autem filia ex toto, sive de patris sive de matris parti, in hereditatem succedat, et tunc temorum hereditas et fusum e lancia tensiat. 8. As far as the 5th generation the paternal kin succeed, but after the 5th the daughter, whether on the father's or on the mother's side, may succeed to the whole inheritance, and then finally let the inheritance pass over from the spear to the spindle. As in the other laws, so under these rules the allod clearly embraced both the land and the pecunia and mancipia upon it. Its object, like that of the similar clauses in the other laws, and also like that of the Edict of Chilperic, seems to have been to protect the land in ordinary cases from passing over from the spear to the spindle, while at the same time sanctioning inheritance by females, even in the land of the allod, when otherwise there would be danger of its passing away from the kindred altogether. In certain cases the land of the allod was made to go to male heirs, while the pecunia and mancipia upon it went to females. Whether the word pecunia in such cases should be translated by cattle, or on the wider word chattels, it must have included the cattle, and at first sight it is not easy to see how the rule would work which gave the cattle of the allod to a female, and the land to a distant male heir. The cattle must in the nature of things have remained, or be put upon the land, and the awkward question arises upon whose land they remained, or were put. And so we are brought once more to the practical question of the position of women in relation to the land, that in certain cases in default of male heirs, they could inherit land is one thing, but the question of the cattle and slaves involves quite another. When a sister received her portion of gwattle under Cymric custom, and when she received so many cows for her maintenance from the chief of kindred, she must have had rights of grazing for her cattle in the family herd of her gwelly. Till she married, her cattle would graze with the cattle of her paternal gwelly, and when she married, with the cattle of her husband's gwelly. And so under the rules of this clause, de allodibus, it does not follow that the distant male heir succeeding to the land of the allod was to evict her and her cattle from it. With the land he had to take also the responsibilities involved in the family holding. Clause 5 states that to whomsoever the inheritance of the land shall come, to him ought to pertain the coat of mail, i.e. the byrnie, and with it the duty of the chief of the kindred to avenge his kin, and to see to the payment of vergeld if any one of the kin should be slain. Read from this point of view, this clause, de allodibus, becomes good evidence that, whatever changes may have been made as to female inheritance, the land of the allod had not yet lost all its tribal traits. It had not yet become the res propria of an individual possessor under Roman law. 5. The so-called Lex Chambevorum. This document, according to most recent authorities, relates to a district between the Frisians and Saxons to the north and east, with the river Meuse to the south. Its real title seems to be Notitia vel commoriatio de illa eva qui si ad amorum habet, and it seems to be not so much a code as a memorandum of the Vergels and finds of a Frankish people settled in the district alluded to. Probably indeed it may belong to the time of Charlemagne, but before his changes in the currency. It is of some interest to this inquiry because of its peculiar position as relating to a tribal people under Frankish rule, and yet with custom of its own which has survived Frankish conquest. The Notitia starts with the declaration that in ecclesiastical matters, as regards the Banus Dominicus, the same law prevails as other Frank have, and then it at once describes the Vergeld as follows. The Vergelds of this law are as under: whoever kills, homo Francus, 600 solidi et pro frida, 200 solidi; ingenuus, 200 solidi et pro frida, 66 2/3 solidi; litis, 100 solidi et pro frida, 33½ solidi; servus, 50 solidi et pro frido, 16 2/3 solidi. Then follows a clause 7, which states that if any comus be slain in his own comitas, the Vergeld is to be 3 times that according to his birth. The homo Francus thus has a triple Vergeld, like the comus, but the comus may possibly be not ingenuus. He may be litis with official position, and so, presumably, according to clause 7, with the threefold Vergeld of only 300 solidi. In the next clause, the royal missus is put in the same position while on the king's business. His Vergeld is also to be trebled. What, then, is the homo Francus with the Vergeld 3 times that of the ordinary ingenuus of the district of Manor? The Vergeld of the latter is the full normal Vergeld of 200 solidi. The homo Francus in this district was therefore very much above the ordinary freeman of other laws. He was evidently a Frankish landowner on a large scale, towering in social position above the ordinary freeman of the district. The casa and curtis of the homo Francus alone were protected by special clauses 19 and 20, and of him alone are any hints given as to kindred or inheritance. Clause 42 in the following few words enlightens us as to his social position. If any Francus homo shall have sons, his inheritance in woods and in land shall pass to them, and what there is in slaves and cattle. Concerning the maternal inheritance, let it go in like manner to the daughter. We must probably consider the privileged position of the homo Francus as presumably the result of Frankish conquest. The great landowner may have been the holder of a benefice or a tenant in capita placed upon the royal domain with ministerial and judicial duties, and the triple Vergeld may fairly be assigned to his official position. But to return to the Vergelds, the payment pro frida seems to have been equal to an additional 1/3 of the Vergeld. From clauses 20 and 33, it appears that the value of an eye or hand or foot was 1/4 of the Vergeld, instead of half as in the Salic and Ripuarian laws. Theft was to be paid for 9-fold with 4 solidi pro frido. The further clauses regarding theft in this border district of forest and cattle and mixed population are not quite easily understood, nor need we dwell upon them. In c. 30, the penalty for letting a thief go without bringing him before the comus or centenarius was 60 solidi, as in the Ripuarian laws. 6. Concluding remarks. Before passing From the laws, the compilation of which seems to date from the conquests of Charlemagne, it may be well to note that, regarded from the point of view of the Virgals, the tribes whose customs have been examined in the last two sections seem to have belonged to the Frankish group with Virgals of 200 gold solidi, while on the other hand, the Frisians and Saxons seem to have belonged to the other group with Virgals of 160 gold solidi. This grouping of the tribes may not be exactly what might have been expected. Geographically, the Frankish group is sufficiently compact. The other is widely extended and scattered. Frisians and Saxons remain in their ancient homes. The Alemannic, Bavarian, and Burgundian tribes have wandered far from theirs, but in their northern home they may have been once sufficiently contiguous to have shared many common customs, and among them a common Virgeld of 160 solidi. Settled in their new quarters, the Rhine and its tributaries seem to have been the great highways of commercial intercourse and the connecting links between them. Immigrants from them all met as strangers at Veni, in the Ripuarian district, and, as we have seen, we owe our knowledge of some of their Virgals very much to the recognition of them in the Ripuarian laws. End of section 18.